Well, hello everyone. We'll give it a minute or two to make sure everyone can join. But in the meantime, just some housekeeping, especially for any attorneys in the audience. This is not a CLE event, technically speaking, but if anyone is applying for CLE credit and they need the materials that will be presented, I will be happy to share those. And if anyone else wants those materials for any reason, I will also be happy to share them. Today's event is titled International Trademark Protection Strategies. And as the name suggests, we will be focusing primarily, almost exclusively, on trademark protection. We might have events in the future where we focus on other types of intellectual property, such as copyrights. But in this case, the focus is going to be on trademarks. And let's get started. We'll start with some basics. So if anyone joins a few minutes late, they won't miss all that much. First, a brief introduction. My name is Fred Rockefort, and I am an attorney at Harris Slowoski, licensed in Florida, Washington State, and Washington, D.C. And I just want to share a little bit about my background and experience, specifically from the point of view of what informs my approach and my attitudes toward the topics of brand protection and trademark protection. Prior to joining Harris Slowoski, I worked for a brand protection consultancy based out of Hong Kong. In addition to serving as their top in-house lawyer, I volunteered to participate in all kinds of activities carried out by my colleagues, including accompanying law enforcement on raids of suspected of facilities where counterfeit activity was taking place or was suspected to be taking place, and also became an authorized examiner for many of our clients when seizures were made and identifications had to be carried out for law enforcement purposes. I'm also a former U.S. diplomat and spent a couple of years working at the U.S. consulate in Guangzhou, China. And part of the portfolio that I oversaw while at the consulate was intellectual property rights protection. And that afforded me a first row seat at a location that was and remains a hotspot, perhaps the largest hotspot in the world for counterfeiting. Also gave me some insight into the policy aspects of intellectual property protection and the challenges that foreign brands face when they operate in markets like China, as well as the intergovernmental, international aspects of coming up with the best ways to protect intellectual property. So let's dive right into today's topic. And first of all, let's very briefly establish, or at least try to come close to establishing, just what is a trademark. That logo that you see in the slide is actually the oldest registered trademark in the United States. It's not the oldest registration, but it's the oldest continuously registered trademark in the U.S. Trademark Register. I suspect that there have been slight modifications to the trademark itself that looks a little bit too modern, but one form or another of this trademark has been registered now for well over 100 years, if my memory serves me well. So I will adopt one definition of the term trademark. There are others, but They won't differ significantly. This comes from the World Intellectual Property Organization, the United Nations of intellectual property, if you will. And a trademark is a sign capable of distinguishing the goods or services of one enterprise from those of other enterprises. So they serve as an identifier of source. They serve to differentiate what one business sells from what another business sells. This indicates that trademarks are intrinsically linked to commerce. A trademark cannot exist in captivity, if you will. Trademarks exist only out in the wild. If you come up with a logo, if you come up with a company name, but you're not actually using that in the context of business activities, then it's not a trademark. It's a word. It's a logo. It's artwork, but it doesn't have that legal standing as a trademark. And this is different than other forms of intellectual property, such as copyright, which can arise even if the use of that intellectual property is private, so to speak. If I write a novel that never gets published, that I still own the copyright over that novel, even if it's not being sold commercially. And the other thing to keep in mind is that trademarks exist in relation to specific goods and or services. You don't trademark a word, really. You trademark a word in connection to specific goods or services. That's why we see coexistence between brands, Delta Airlines, Delta Faucets, Dove chocolates, and Dove shampoo, etc. There are a number of trademarks can take a number of forms, but the most common are word marks and design marks, and both are depicted here. Word marks are, as the name suggests, basically the word without any without any particular font, size, color, etc. When you register a word mark, the protection you obtain covers any kind of representation of that word. By contrast, design marks are basically are connected to a specific design, which can include wording, and in some cases it is entirely wording, such as the stylized Coca-Cola wording, or in some cases it can be a graphic element without wording. There are other types of trademarks. In recent years, we have seen more attention being paid to non-traditional trademarks, scents, 3D trademarks, etc. But for purposes of our presentation today, we don't need to go into that in detail. So why protect trademarks? Well, the first reason, and I think most people understand this intuitively, is to prevent others from using your brand, right? This is good and desirable from the point of view of the brand itself. For example, we can understand why Starbucks would not want to operate in a marketplace where I could go out and open a store called Starbucks Coffee and not have any legal and not face any legal consequences. At the same time, it's also good from the point of view of consumers. You don't just imagine a marketplace where if you walked into let's say a McDonald's, you were not sure if that McDonald's was one connected to the McDonald's Corporation, or whether it might in fact be run by someone else, or be a one-off store unconnected to the the larger chain. Um, Protection against unauthorized use of a trademark is not only a matter of ensuring that you get consistent service and consistent quality, but it also ties directly with questions of public safety and public health, right? Just think of medicines, just think of foods. We want to be able to link a particular product to the source of that product. For this reason, the existence of a trademark, especially one that's recognized, and even more so one that is registered with the government authorities, can help establish customer trust. People see, okay, this is not just anyone using a name. There's a public record of who owns this trademark. And from the point of view of businesses, protecting trademarks can facilitate growth and expansion. It allows your image, your brand, which to some degree is let's say a somewhat indefinite concept. It allows you to start making it something more concrete, right? A trademark can be sold, can be licensed to others, and it forms a kind. It is a kind of property that allows you as a business to monetize aspects of your business that might not be tangible, but nonetheless are real. So now that we have established what a trademark is and how to protect them, let's go into the basics of protecting them internationally. We will touch upon domestic protection by necessity, both in the U.S. and other countries, but really the focus here is on protecting trademarks across borders. We can adjust the point of view of a U.S. company looking overseas, looking at other markets, but the same logic applies to companies from other countries looking to do the same thing, right? So a Canadian company looking to grow outside of Canada, or a European company that's looking at a global strategy. And apologies for that why that didn't fit next. That went down by itself. And same thing here. So apologies for that. So every country has IP laws. Even North Korea. I always like to point this out because it is something that comes up. People say, well, surely there must be countries that don't really have IP laws, but in essence, every country has intellectual property laws, and it is interesting when I attend professional events, conferences, to run into professionals, colleagues, really, who are doing work in places like North Korea, places like Cuba, where frankly places where with which we frankly don't have that much contact. It's very rare to have matters involving these countries, and it is rare to have matters involving these countries, even in the trademark world. But at least I know that the people who practice in these areas exist and are out there can say the same about other areas of North Korean or Cuban law. So while every country has intellectual property and trademark laws, the laws are not the same. There is a distinction, not a particularly sharp one these days, but there is a distinction between countries that follow what is known as the first to file principle and those who apply the first to register principle. And basically what this means is what it sounds like. In some countries, whoever files an application first to protect a trademark will have the superior right. In other countries, it's whoever uses it first. And again, apologies, this should be first to file and first to register are essentially the same. The counterpoint to these is first to use. So first to file versus first to use. This does not mean that unregistered trademarks have no protection even in first to file countries, but those protections are far less. I think it's fair to say that the United States is probably the country that provides the most protection for, or one of the countries that provides the most protection for unregistered trademarks. And even then, there is a difference between the protection that they receive and the protection given to registered trademarks. And in some countries, that protection might be zero. So just to illustrate, so just to give some examples of countries that follow each system. So the U.S. is perhaps the preeminent country that follows the first to use model. It is often said that countries that form part of the Anglo-American legal tradition will tend to follow the first to use rule, whereas countries that belong to the continental European tradition follow the first to file rule. There is some truth to this, but at the same time, it's not absolute. And in fact, the UK, for example, is basically a first to file country. That might have something to do with the fact that for a long time, UK trademark law was aligned with that of the EU. And Canada is another country that is generally considered to be a first to use country. China is certainly one first to file country with which we deal quite a bit. And again, even though these are not absolutes, it is a reality that we face on a regular basis. I think it's when looking at this issue, I think it's reasonable to treat countries as if they follow the first to file rule and proceed accordingly. And if you discover that a country is more permissive when it comes to the use of unregistered trademarks, then great. But it's of limited comfort, frankly, even though the law in a country might theoretically provide for first to use trademark rights. Enforcing those rights means proving that, possibly going to court, whereas by formally protecting your trademarks, you can avoid those complications. So a lot of similarity between trademark laws, but also some significant differences. Some trademarks that might be perfectly registrable in a particular country might not be in another country for a variety of reasons. Those could have to do with the trademark itself, and those could also have to do with the goods and services that are connected to them. So let's talk about trademark registration, which is an essential part of trademark protection. It is not synonymous with trademark protection, but it is certainly an important part of any trademark protection strategy, whether at the national level or internationally. So as I mentioned earlier, protection of unregistered intellectual property, and especially trademarks, may be weak or in some cases none. And especially in first to register countries, registration by another party can be catastrophic. Even in first to use countries, the consequences could be quite severe. But just to illustrate this, I have a few horror stories that I could share, but for example, I know of a situation where a company, relatively well-known European company, although not massive, had to pay approximately 200,000 US dollars, and this was about 10 years ago. So probably more in today's terms. They basically had to pay that amount to take ownership of one of their marks that had been registered by someone else in China. So it can be, well, for some companies, $200,000 might be an inconvenience, but for others, of course, it can be a complete disaster, right? To have to pay that kind of money, and could in fact in some cases be fatal. So one question that comes up often is where to register trademarks, or where to actively protect trademarks, and this is going to depend on the specifics of the business. This is not, let's say, these are just some general thoughts on this, some general guidelines. But we'll in the typical situation, we will recommend registering the trademark in the home country of the business, and in their key sales markets. Often there is, of course, overlap between these, and then it is also important to set up protection in places where manufacturing is taking place, and this is a blind spot that we see quite often. Companies will say, well, we sell in the US, we sell in Canada, we sell in the EU, we manufacture our products in China, but we don't sell there. We don't have any interest in ever selling there. And they think that trademark protection in China is something that they can ignore. But this is not the case. And in fact, if a company does not register a trademark in the markets where it manufactures, even if it doesn't sell in those places, the consequences can be serious. Others could go ahead and register trademarks, the trademarks that owned by that this company should rightfully own, and then make your life very difficult. For example, they can take this if someone registers your trademark before you do, then they could, for example, go to the local customs authority and say, we're the rightful owner, and we want you to take steps to block exports by this other company who is not the authorized, the registered. It's not the owner of the trademark. We are the owners in this country. Or they could go to the local enforcement authorities and say, there's a factory that's producing widgets under our brand, and we want you to take action against them. And unfortunately, this is a risk that might even be present in countries where your brand doesn't manufacture. So let's say, for example, that there's a European company, they make luxury handbags, and they are of the view that the only place where they're going to get the quality that they want for their products is in Italy, right? That's where they've been making them for 300 years, and that's where they will continue making them. That said, counterfeiters might say, okay, well, we're going to make fakes of this product elsewhere. And China is, for better or worse, a country that often comes up in this conversation. Sometimes brands will come to us and say, we've specifically avoided China because we do not want to deal with the threats from counterfeits. And while not manufacturing in China can reduce certain risks associated with counterfeiting, it doesn't prevent someone from producing those counterfeits and trying to get them into your your core markets. So it's important to keep this in mind, that sometimes it makes sense to protect your trademark in countries where you don't sell or even manufacture. In this sense, I always recommend that brands think of where they want to be going forward. Maybe at the moment you are only selling domestically, or perhaps just selling across the border to Canada. But if you're thinking that in 5 years you want to be present in other markets, this is really the time to start looking at setting up a protective net, not 5 years from now when all sorts of things could have happened. Maybe someone else registered that trademark, that's the biggest risk. But certainly better to take care of things early on. So how to go about obtaining trademark protection in other countries, right? Again, let's just, for our purposes here, let's just take the perspective of a U.S. company that wants to obtain trademark protection in other markets. Well, there's two ways to go about this. One is to file applications directly with the national authorities, the national trademark offices in all of the countries that you're interested in. And the other option is to take advantage of the international trademark registration system. I want to clarify that when we talk about this international trademark system, it's international in the sense that you can file an application saying, I want to obtain protection in this country, that other country. But then the application gets sent to the authorities in each country. So in the end, you're going to be facing an examination of your application by all of the countries that where you want protection. But it does, the consolidated process can facilitate things. There are some things to keep in mind. And by the way, just one thing to mention, there are some examples of jurisdictions that will offer protection in more than one country. And the best example of this is the European Union. You can actually apply for what is known as a European Union trademark, which offers protection in all, I believe there are 27 at this point, all 27 member countries of the EU. When considering how to go about this, there are several considerations, cost being one of them. If you're only looking to extend your trademark protection to one or two countries beyond your home country, an international application is probably not going to be cost effective. It's going to be more expensive than just applying directly with the national offices in those countries. And the national applications have the benefit of allowing you to tailor them. You just think of taking a trip to Mexico and how you would pack, as opposed to taking a trip that's going to take you to all of Latin America. You would pack differently, probably. And this is what happens really with a national application. Typically, it can be tailored perfectly for the conditions and in Mexico and the requirements of their national office. With the international applications, you're basically going for a one-size-fits-all that might not fit perfectly in some countries. In addition, these international registrations are vulnerable to what is known as a central attack. And this, it's not really an attack. It just means that if for some reason the international registration is canceled, then everything that stems from it will be impacted. The international applications have to be based on a national application, typically. So in the case of a U.S. company or U.S. individual, they'll apply for protection in the U.S. first, and then that U.S. application or eventually U.S. registration will form the basis of that international application. And if the U.S. PTO ends up refusing that U.S. application, that's the U.S. Patent and Trademark Office, just in case someone out there is not familiar with the term. If they refuse the application, then that impacts the entire international application. So this is something important to keep in mind. There are ways of essentially converting the international application to national applications in the different countries, but it's a cumbersome process, and the possibility of this happening is something that has to be taken into account when making these decisions. At the same time, these international applications can be very helpful when you're seeking to extend your trademark protection to a large number of countries. Even us as lawyers, dealing with 30 different applications at the same time across countries can be overwhelming. You're dealing with different service providers, different rules, different currencies, etc. So there is definitely something to be said about the international system, also known as the Madrid system, in cases where the number of countries is large. It also offers the benefit of centralized renewal, which again just makes life easier. If you apply in 30 different countries, filing 30 different applications, assuming all of them are successful, then in 10 years from now, you're going to be looking at renewing applications, possibly with different renewal dates. The international system helps you deal with this in a pretty efficient way. Most countries are part of the Madrid system, of the international system, but not all. And this obviously can be an important factor. There are several countries in Latin America that are not part of the system. There are several countries in the Middle East that are not part of the system. Hong Kong, which has a separate trademark system from mainland China, is not yet a part of the system. They're in the process, and they've announced several times that they're close to accession, but last I checked, they still haven't done it. Taiwan is not a member of the Madrid system. So there are some significant economies out there that are not part of the system. Places in Latin America like Peru, Uruguay. So definitely a factor to keep in mind. If a significant number, let's say you want to expand your protection to 6 countries in Latin America, and 4 of them are not members of the system, then it might just make sense to file national applications. So some practical considerations, and these apply regardless of whether you're applying directly with national offices or whether you're availing yourself of the international system. Registrability of trademarks. You have to consider whether there might be any issues that impact your ability to register your trademark. One of these is ensuring that there are no conflicts with trademarks that have already been registered or for which pending applications exist. You have to look at issues such as descriptiveness, deceptiveness. These are almost across the board going to be problematic. Local languages, you have to take into account whether you might want to obtain protection for your trademark in a or whether you might want to translate your trademark and get protection locally. Not just, let's say you have a trademark in English you're going into Mexico, depending on the trademark you use, it might make sense to come up with a Spanish version of it. So just looking at one of the questions that has come in. So the question is the following: going to what you said about trademarks needing to exist in the market before they can be registered, can a brand planning to enter a country like China register their trademark before actually being in the market there? And the question is yes. And then the answer, sorry, is yes. So countries, and we'll touch upon this later, countries have different requirements as far as use. So China does not require an applicant to be using the mark in order to file an application or even to obtain registration. And there's actually no requirement to demonstrate use of the trademark during the term of registration. However, China and many other countries provide for cancellation of trademarks if they are not used. So in China, the way it works is if a trademark has not been used for 3 consecutive years or more, then an interested party can apply for cancellation. And this is actually something that we do all the time. Sometimes we have clients who apply for a trademark in China and they discover that someone already registered their trademark. If enough time has passed, we can request cancellation of that trademark registration. In other cases, there might be a trademark that's not actually identical to our client's trademark, but similar enough that the China Trademark Office considers there's a risk of confusion. Again, if the right time has, if a sufficient amount of time has passed, then we can request cancellation. In the United States, it's different. Use has to be shown before the trademark can be registered. You can file an application prior to that, but registration will not be complete until you demonstrate use. There's one exception to that, and we'll talk about it later, and that's when the U.S. application is based on a foreign application. Other countries usually, there are a lot of countries that sort of follow the same approach as China. Other countries have approaches that are closer perhaps to the US, but not as strict. So for example, Mexico does require the filing of declarations of use at certain moments in time, but proof of use does not have to be submitted. So of course, the declaration is a legal statement on the part of the owner saying, I am using it. But as a practical reality, it's not a huge obstacle for some brands out there that want to keep their registration valid, even if they're not actually using it, which of course they shouldn't do, but it does happen. So as it happens, here we have our slide on use requirements. Just very briefly, as I mentioned, one exception for the requirement to demonstrate use of a trademark prior to registration in the US is where the basis of the US registration is a foreign registration or an international registration. So the way this works is, let's say that a company from the UK has a registered trademark in the UK and they want to apply for protection in the US. They can basically file an application here in the US and claim as the basis of that application their UK application. The US application will need to match the the UK application. So basically has to be the same trademark. It has to be the goods or services have to be roughly the same. You can reduce the scope of your US application, but you do have some limitations in terms of what you can do. But this can actually be a very valuable pathway for especially for foreign companies that are looking to get protection here in the US. So as I mentioned earlier, some countries have requirements to declare that use is taking place at certain points. Yeah, again, usually it's not necessary to attach proof of use, although there might be some countries out there that do. Just haven't run, and maybe North Korea does. I don't know. And yeah, some countries don't require use of the trademark at all. So I want to talk a little bit about the local issues, the special circumstances that might impact your trademark protection strategies. So one thing that happens sometimes is that consumers in a foreign market will come up with different names for your product, especially names in their local language. And ideally, you will think this through beforehand, in advance, and you'll select the name that's appropriate and really promote from the start using that chosen name. But there are circumstances where that just doesn't happen, either because, well, the company doesn't think about this, or the market wants to come up with a different name. In those cases, it generally makes sense to sort of embrace those names and get protection for them. The last thing you want is a competitor or someone acting in bad faith to register that foreign language, local language variant. In some cases, you will need to get creative. When Burger King initially sought protection in Australia, they discovered that there was someone else who actually had registered that trademark. So they basically decided to brand as Hungry Jack's. My understanding is that eventually there was some sort of solution reached, but by then the Hungry Jack's name had become quite famous in its own right, and I believe that it's still being used by Burger King in Australia. Also, for example, in Quebec, they have French language requirements. So KFC basically has to be PFK. I'm not going to try to pronounce the French name of KFC. And of course, when you're faced with a situation like this, then it makes sense for brands to say, okay, well, we might not like the fact that we have to come up with different branding for this market, but we have to do it. So these trademarks need to be protected as well. It's also important to, when you're choosing alternate trademarks, local language trademarks, choose carefully. Make sure that you are consulting with someone who knows the language. You don't want to be choosing a name that has negative connotations. And this can be quite tricky, right? Even someone well-meaning who is fluent in a particular language might be missing something about a chosen name that could create problems. So you've registered your trademark. Now what happens? So registration is only the beginning. It's an important part of the process, but it's only the beginning of a robust trademark protection strategy. Things you can do and should in fact do is record your trademark rights with customs authorities. So for example, if you register your trademark in the US and this is where you sell, you can ask US Customs to be on the lookout for counterfeits of your products. You can ask China Customs to be on the lookout for counterfeit exports. So this cooperation with customs agencies can really amplify the scope of the protection you get from your trademarks, and it's usually a very cost-effective add-on, if you will, to trademark registration. Keep tabs on the marketplace. In some cases, you'll find out about counterfeiting activity. in some cases, it might not be that obvious, or it might not be something that you are informed of passively. It may require more vigorous oversight of the markets where you operate. Related to this, keep an eye on what is happening as far as trademark registrations go. If someone is trying to register a trademark that is similar to yours, if someone is trying to register something that looks like the local language version of your trademark, it's better to know about that, and if necessary, if you consider it prudent, take action to prevent that trademark from being registered, and then enforce your rights. And let's just talk a little bit more about this. When we say enforcement of trademark rights, what are we talking about? Well, this is going to vary from country to country, but there's essentially a whole panoply of options that are available. In some countries like China provide administrative pathways to enforcement, which are not quite, they don't involve application of the criminal law. These are rather, as the name suggests, administrative proceedings. And because of that, because no one's going to jail after they get caught with counterfeits, the rules are often a little laxer in terms of what you can do. The punishment that the counterfeiters might receive is less, but at least it's just an easier, more effective way of taking action. Of course, in some cases, taking steps to prosecute counterfeiters criminally will be worthwhile, and those options might be there. And there's also the possibility of suing someone, right, for the damage that they have caused. And one benefit of suing is that this can result in some form of financial compensation to the affected brand that can in turn help fund ongoing brand protection efforts. Nowadays, a lot of the commercial activity takes place online, meaning that a lot of the counterfeiting and trademark infringement is also taking place online. And therefore, for many brands, incorporating an online component is absolutely essential to their enforcement strategy. The principal marketplaces, Amazon, Taobao in China, they have well-established systems to deal with infringements. This is not to say that the way they function is perfect, and in fact, they can sometimes be the source of frustration to brands who report infringements and for whatever reason don't see action. But of course, that by no means should be an invitation to just give up on enforcing your trademark in the online realm. Cease and desist letters are a valuable tool. They are sometimes ignored. Some people are not, surprisingly, not everybody's scared by a letter from a lawyer, a nasty letter from a lawyer telling them to stop doing something, especially if whoever it is already decided that they're going to embark on the path of using someone's intellectual property without authorization. But it helps establish a record of what you're doing. It shows that you are taking steps to protect your trademark, and it is sometimes a necessary step towards more aggressive action, or at least a recommended one. Trade shows. I mentioned this because, well, trade shows are also a problematic arena from the point of view of trademark infringement, not only because people are using trademarks without authorization, but because they can potentially sell infringing products to people from all over the world who are then going to go and sell infringing products God knows where. magnifying or maximizing, I should say, risks possibly across the world. So it's worth keeping an eye on relevant trade shows for your industry, and doing what you can to keep track of what happens there. And in some cases, the organizers of the trade show will provide avenues for enforcement on the spot. So as we wrap up, just want to go over some best practices. First, just reiterating what was said during the presentation: register. This is really the cornerstone of any trademark protection strategy. It's not, like I said, it's not synonymous with it. It's not the only thing you have to do. And in some cases, registration might not be possible for a variety of reasons, and those situations can be very challenging. But it's not the end of the story. But if registration is a possibility, we strongly recommend that. Carefully select your local representatives. This really applies to this really applies to everyone that you're dealing with abroad, but specifically people who help you with trademark protection. Make sure they're reliable, make sure that they're competent, and if in doubt, try to get some further advice. Sometimes local service providers will be called upon by foreign brands to help them with things that they might not really be comfortable with, in terms of anything from choosing a name in the local language to helping them find the best description for their product as part of their application. And sometimes they'll do the best they can. They'll give it a try, but ultimately it's your responsibility to make sure that those applications are the way they should be. Again, monitor the marketplace for infringements. It can be tempting to turn a blind eye to what's going on and just focus on your core mission of offering a particular product or service, but this can be a risky approach. It's better to be proactive about knowing what's happening, and ideally get a handle on things as soon as possible if there's an issue. When investigating, when exploring what's happening in a particular market, look organically, look at the entire supply chain. Focusing on the people that are selling products. It's an important part of the strategy and can offer some initial satisfaction to see some stores being raided, some online vendors have their listings taken down. But this is you're then just playing that game of whack-a-mole where someone else is going to come up and is going to do the same thing. So to the extent possible, try to go up the supply chain, go for the factories that are supplying to different vendors. That's not always easy, but it should be the guiding principle when carrying out these efforts. Very important point. Remember that your suppliers, your own suppliers, often are the greatest risk, and this is both because of what they do and because of what they don't do. In some cases, you might unfortunately work with a supplier that wants to compete against you, wants to make unauthorized copies of your product, etc. And this can happen. And in this case, protections such as trademark registrations might be of limited use because those factories, if they're making your product, they're doing so under your authorization. So those products are technically not counterfeit. So having strong contractual protections is a very important part of the brand protection and trademark protection strategy overseas. Suppliers can also be a huge problem because of what they don't do. Maybe the people you deal with, the managers, the owners, they don't want anything to do with counterfeiting. They don't want to. They want to have a healthy business relationship with you, but is that going to extend all the way down to the people working on the factory floor? And the reality is that it might not. So that's certainly a risk that you need to think about and then look for ways to address. Often it's not about what anyone at the supplier is doing, but about the security lapses that they allow to happen, right? Maybe they don't control access to their facilities. People are coming in, taking a look at designs, things of that sort. So keep this in mind and act accordingly. And build relationships with law enforcement in the different countries where you operate. Don't neglect the people who are doing the hard work of actually trying to prevent these activities. But I say cleanly because these can be challenging environments in which to operate, and unfortunately, corruption is a reality in many markets around the world. And as American companies, but also companies from other countries that have strong anti-corruption laws, you have to be very careful about what you do. Sometimes corruption or the invitation to participate in corrupt activities isn't obvious. So tread carefully. In terms of the legal system, and this is related to the point I just made, embrace the local systems. There sometimes companies have a reluctance to engage with local systems for a variety of reasons. It's too different. They don't understand it. They feel it's not efficient. And there may be some truth to this, but ultimately this is not conducive to a proper trademark protection strategy. So be an active participant in that system. Take advantage of the legal proceedings that are available, and ultimately help build the environment that you want. If you are frustrated about a country's relative lack of zeal when it comes to protecting trademarks, are you are you positively contributing to making a change, or are you sort of just buying into that frustration and not really helping that country develop better capabilities to deal with things? Finally, brand protection is an across the board effort. Even at the point where you're designing a product, you should be thinking of brand protection. Some products would give you the option of incorporating features that make life harder for counterfeiters. Take advantage of that. And finally, your consumers, your customers, your clients in around the world, especially the happy ones, are incredible advocates, and they can really help you with understanding what's going on in terms of counterfeiting. So look for ways to engage with them to the extent possible. Give them tools and motivations to work together with you to protect your brand. And with that, thank you. If anyone has any questions after today's event, please feel free to reach out by email. My email is fred@harrislewosky.com. Look me up on LinkedIn. I'll be happy to connect. And just before we go, I know we have a question. So, I don't know. There's if I know someone just send me a question. If I could trouble you to connect with me via email, I'll be happy to talk a little bit more about this issue. So thank you so much. Thanks for the comments, and I look forward to seeing you all again in the future.